Welcome back, Unfiltered family. Today we are going in a different direction, so don't escape. Don't escape. I promise you it's going to be an interesting one. You know, there was all the buzz and the hype about Maweni, but I couldn't stop to think of Nandipha Magudumana when it comes to the results of their bail applications. If you've clicked on this video and you're watching this video now, it means you saw the title already. So I want to dive into lessons from Gogo Maweni's bail application versus Nandipha Magudumana's application. Why am I comparing the two? I know. There's going to be those that are saying, it's not the same thing. I know, okay? I know, but stick with me, okay? The reason why is because they're both Instagram personalities. That's the first thing, and they're both doctors in their own manner. Gogo Maweni, who loves to refer to herself as Dr. Maweni, unfortunately over there at the court, they read out her education, and I didn't hear anything with regards to the doctor side of it. I might have missed it. Let me know in the comment section if you heard it. Dr. Maweni has 414,000 followers on the Instagram app, and Nandipha Magudumana has 143,000 followers at the time of her incarceration. Keep in mind, she was denied bail. So today, we're going to break down two high-profile bail applications that had Mzansi talking, okay? Gogo Maweni and Dr. Nandipha Magudumana. What lessons can we learn from these? This is the real reason why you want to stay and watch, because I believe Gogo Maweni's bail application, other than being highly entertaining, it also brings in a lot of lessons that, you know, as she called herself, a layman in law, we all need to pay close attention to, okay? So what lessons can we learn from these cases, and why were their applications treated so differently? Stick around, because this one is going to be insightful. Please remember, just go ahead and like the video right here so you don't forget later on, okay? Let's jump straight into it. You know, I'm not even going to hold you. I am not going to hold you. First, let's quickly recap what led these two women to court. Gogo Maweni, known for her controversial social media presence and alleged spiritual work, found herself facing legal troubles after she said one or two or three things too much over there on the tickety talk, okay? She did too much. She, you know, created a coffin as well. I'm not going to go too much into the merits of that. I'm sure you've seen multiple times coverage on that. I didn't cover it, you know, because it was like, okay, whatever. But, you know, now we're covering it because I want us to take a look at these insightful lessons from her bail application, okay? So she found herself facing legal trouble, leading to her recent bail hearing. Meanwhile, Dr. Nandipha Magudumana, infamous for her role in assisting convicted rapist and murderer Thabo Bester, has been trying to fight her way out of prison since her arrest. Let's talk about why their bail applications were handled so differently. What made one successful while the other faced major obstacles? You do know Nandipha Magudumana, at the time of her incarceration, was a mother of two very, very young girls at the time. And Dr. Gogo Maweni is a mother to 3 young children and is pregnant with twins. So keep that in mind, okay? We'll talk about it later in the video. So what made one successful while the other faced major obstacles? Keep those 2 points I put across to you at the back of your head. First of all, the nature of the charges. Gogo Maweni's charges, though serious, were not linked to a well-organized criminal scheme. Nandipha, on the other hand, was accused of masterminding an elaborate escape plot with Thabo Bester. The court saw her as a flight risk. Point number 2, evidence presented in court. Maweni's legal team, Mlungu, let me tell you, Mlungu, I think I'm going to do a whole separate video on Mr. Mlungu there, because Mr. Mlungu did the things, okay? Maweni's legal team argued for her release, showing that she was not a flight risk and had strong community ties. Dr. Nandipha's case had overwhelming evidence of her involvement in Bester's escape, which made the court hesitant to grant her bail. So let me just expand on this a bit. Dr. Maweni's legal team, okay, Mr. Mlungu there, they immediately volunteered the passport. They were like, you can take the passport, but please no, I need to travel. I need to travel for my work. And there's 4 people that I've employed. They rely on me. My work requires me to go to other countries such as this and this and this, because I gotta go and look for this and this in those countries. So but here's the passport anyway. I would rather be granted bail but fight over the passport. Okay. Nandipha Magudumana, on the other hand, was found over there in Tanzania. She was found in Tanzania already. Okay, she says, I was kidnapped. Okay, I wasn't there on my own free will. Thabo Bester, he took me. Okay, he took me against my free will. But I was there. But then you also have Dr. Posh, I think she is. Dr. Posh's passport was found in your possession. What is that? So Nandipha's situation was very, very different with regards to who's a flight risk and who's not a flight risk. Do you agree that Dr. Maweni or Gogo Maweni is not a flight risk? Go ahead, type a 1 in the comment section down below. But then let's go ahead. And now Dr. Maweni's legal team argued for her release, showing that she was not a flight risk and had strong community ties. She had such strong community ties that she can hit that live button on that Instagram, okay, and thousands of people show up. Okay, I could be wrong, but I think the last time she or she or Gogo's Koteni was online, I believe it was 60,000. I think I heard rumors about 60,000 people showed up for that live. Correct me in the comment section if you know the answer. Dr. Nandipha's case had overwhelming evidence of her involvement in Bester's escape, which made the court hesitant to grant her bail. Number 3, public perception and media influence. Maweni's case, while controversial, did not carry the same national security concerns as Nandipha's. Okay, Magudumana's case had the entire country watching, making her bail application highly scrutinized. Drop a 2 in the comment section. Let me know if you agree with this point. Did you follow Maweni's case or you followed Magudumana's case? Drop a 2 in the comment section. Let me know if you believe that yes, Magudumana was highly watched by the entire country. Okay, point number 4, the flight risk factor. The court was more lenient with Maweni, even though she called her dishonest. But I'm going to cover that in a separate video where we talk about from dishonesty to bail approved, okay? The court was more lenient with Maweni, seeing her as unlikely to flee. Imagine fleeing as a pregnant mother. 3 young children, pregnant with twins, trying to flee the country under the cover of darkness, with your husband in tow, loves you so much. Whereas Dr. Nandipha Magudumana, she dropped those kids off at school and left. Said goodbye. Nandipha had already proven she was willing to flee when she was caught in Tanzania with Bester, making her application extremely difficult to win. What are some of the lessons that we can take away from this? So, what can we learn from these 2 cases? Lesson 1, the severity of charges plays a huge role in bail applications. If the crime suggests a risk to public safety, bail is less likely. Lesson number 2, flight risk is a major factor. If you've already shown a willingness to run, don't expect the courts to trust you with bail. Lesson number 3, media coverage matters. High-profile cases like Nandipha's put pressure on courts to make an example out of the accused. Today, we have Umusa Kaula in the courts. But Umusa Kaula, in his own words, he's Wendy William Light. He's just all about the talk. Well, he is also a suspect in a murder charge. And then there's another one for attempted murder. And then it's a lot, okay? But it's the severity of the crime. Let me know in the comment section, do you think Umusa Kaula is going to be granted bail? But let's go back to lesson number 1. The severity of the charges plays a huge role in bail applications. If the crime suggests a risk to public safety, bail is less likely. You see, Maweni is not a risk to the public. She's a risk to the relatives of her baby daddy. Okay, so the complainant, whom she allegedly attacked, is known to her. Well, they're known to each other. Apparently cousin to the father of her third child. And they were battle of the giants. You know how it is in the families, how it goes. Some families, at least, it can get physical. In this case, Maweni allegedly got physical with the accused, and they know each other. So it's really kind of like a one-on-one kind of battle. Whereas Nandipha Magudumana, she's taking bodies. Okay, she's taking bodies. We're not sure what she's going to do next, allegedly. Okay, because the merits of that case have not yet come to court. That is going to start, I believe, in May. So you know what? I definitely want to hear your thoughts on this. So that's a wrap. What do you think about the differences in these bail applications? Do you think justice was served in both cases? Drop your thoughts in the comment section down below. You already know what I like, okay? Like this video, share this video. And if you're not subscribed, watching from the club, outside the club, because this video might be attracting new friends, please make sure that you subscribe to the channel. And you know what? Until next time, I'm going to drop the parts that I found interesting from Maweni's hearing right over here. And man, I never seen her look so scared. Never seen her look so scared. In any of the lives I've ever watched her, I have never seen her look this scared. She was petrified. Okay? She looked like she was going to cry at any moment. Or maybe those were the pregnancy hormones showing themselves. But did pregnancy save Maweni? Did pregnancy save Maweni and got her the bail? I don't know. But I definitely want to hear your thoughts on that. Let's go ahead and chat in the comment section. I'm going to add the rest of the clips here.
Reside with me. My children have no contact with their fathers, and none of their fathers contribute to their maintenance at all. All my children are dependent members on my medical aid. I submit that I'm the primary caregiver of my 3 minor children. My children are dependent on my daily physical, emotional, and financial support. I have a very close and loving relationship with my children. My arrest and subsequent incarceration have left my children extremely traumatized with an unbearable emotional burden. Paragraph 11, I submit that I'm pregnant with twins. I attach here to a copy of my ultrasound scan confirming that I expect twin babies, marked annexure MMM6. I pause to state that at Johannesburg prison, where I've been detained since my first appearance in court, I was again tested to confirm my pregnancy, whereafter they relocated me to the section for pregnant women. I am on a treatment plan to receive special medication for my pregnancy. This medication is essential to support my pregnancy and to ensure the best outcome for the babies. However, I am not allowed any prescription medication in prison, and the medication they supply me in return makes me nauseous and causes me to vomit. It also suppresses my appetite, which is not good for my pregnancy. I'm also required to follow a specific diet to support a healthy pregnancy. I attach here to the report from Vita Lab dated 20 January 2025 confirming my required treatment as annexure MMM7. I respectfully submit that my continued incarceration might result in a life-threatening situation for my unborn babies and me. At Columbia High School, I matriculated at Maryvale High School, Orange Grove. 2. I generate an income of approximately 70,000 Rand per month from the proceeds of my company. As stated above, I do not receive any maintenance for the minor children from their biological fathers. I alone contribute towards their upbringing and maintenance. Point 3. I own the immovable property bought in Fairlands, Randburg, bracket 107 5th Avenue. I'm busy doing renovations to this property, and upon completion, we, bracket, me, my husband, and our children, close bracket, will move there too as a family. I also own a property in Deep Kloof, Zone 4. I rent this property and receive an income from the rent of 18,000 Rand per month. I also own a townhouse in Oakdean, Balboa Park, and my rent income from this property is 8,000 Rand per month. Point 4. The value of the immovable properties is approximately 4.5 million Rand. The properties are not bonded. Point 5. I possess movable assets, bracket, household furniture, fittings, and appliances, close bracket, of approximately 400,000 Rand, excluding personal belongings and clothing. I also possess a BMW 420i 2023 model with a market value of approximately 650,000 Rand, and a Ford Ranger LDV 2014 model with a value of approximately 300,000 Rand. The Ford Ranger is paid in full. Paragraph 13, I submit that my residential address is valid, fixed, and within the jurisdiction of the above mentioned Honourable Court, where I will stand trial. My residential address should be common course between the state and the defence. 14, I have an amount of 5,000 rand available for bail, but will be able to raise further funds with the assistance of my family and friends should the court find a higher amount appropriate. Roman law 3, history of antisocial behaviour, paragraph 15.1. I have the following previous convictions. Point 1, I was convicted of assault GBH in 2017 and was sentenced to a suspended sentence. Point 2, I was convicted of fraud in about 2015. I was accused of fraud by my employer because I passed the credit for product that I bought from them and did not let a different manager do it. As far as I can recall, I did community service for 3 months. I'm unable to recall the exact sentence I was imposed. Point 3, I also pleaded guilty to driving under the influence of alcohol approximately 15 years ago. I do not recall the sentence handed down, and a recent application for police clearance before travelling abroad did not reflect the conviction. Point 4, I mentioned to my previous attorney of record that I do not remember the exact details of my previous convictions or sentences. During my first court appearance, she may have mentioned that I do not have any previous convictions or sentences, although I am not entirely sure. I submit that I'm a lay person when it comes to court procedures, despite my previous encounters with the law. Your Worship will notice that 15.1.5, if you perhaps, if I may request you to turn the page, there's an inserted page at the back, and I will then return to the previous page, and I will then proceed reading from 15.1.5. Apart from the above, there might be further previous convictions that I failed to disclose. My failure to disclose is not the result of malice or to mislead the court. I submit that I never expected to be arrested and treated this way. I was extremely traumatized and confused because of my arrest and detention. As a result hereof, I started bleeding. It appears that a misunderstanding between me and my previous attorney happened. I meant to say that I have previous convictions, but the nature and the detail thereof I could not recall. I unequivocally state that I did not intend to mislead the Honourable Court, as my freedom depends on this application. I then take you back to page number 8, Your Worship, 15.2. I do not have any outstanding or pending cases. Before this Honourable Court on Monday, 20 January 2025, and the matter was postponed to 27 January 2025, during which I was ordered to remain in custody until then. 6. The complainant in the matter is the cousin of my third son's father, Siyabonga Zulu. Point 7. On the day of the alleged incident, I attended a public appearance in Soweto. The complainant and her friends or family were there too. About 5 people approached me in the street and started shouting and screaming at me. The verbal abuse turned violent and I had to defend myself against these attackers. Siege Zulu was one of them. My phone was stolen during the altercation. Members of the public intervened and pulled the attackers off me. I then left for my home. Point 8. At the time, I filed the criminal charges against the complainant and her accomplices at the SAPS. After having filed charges, I never heard from the SAPS again. Apart from phoning the police station on a few occasions, inquiring into my complaint, I did not pursue the matter. The incident transpired more than 5 years ago. The matter serving before the Honourable Court appears to be a classic example of 2 persons having filed counter charges against each other, wherein only one of the complaints is investigated and pursued more than 5 years after the fact. I submit that I was the victim in the matter and not the complainant. Point 10. The complainant and my third son's father, Siyabonga Zulu, knew my details and whereabouts all along. 11. I vehemently deny having committed any offence of any nature. I submit that I raised a bona fide defence. I submit that the state has a weak case against me. I will in all probability be acquitted upon the conclusion of the trial. 24. I respectfully submit I do not pose a threat to the safety of the public or any particular person. I harbour no resentment towards any person and have not threatened any person in this matter. I submit that the allegations are serious. I submit that I'm presumed innocent until proven guilty. I respectfully submit that my release will pose no threat to society. I respectfully reiterate that I do not have any outstanding case. I'm pregnant with twins, unable to function in prison, and do not have access to my much needed medical treatment and medication. The prison does not cater for my specific dietary needs referred to supra. My continued incarceration might very well result in a miscarriage and a life-threatening situation for me. The circumstances prevailing in prison are simply not conducive for a pregnant lady like me. My condition renders me a soft target for criminal activities prevailing in prison. Paragraph 42. If I'm not released from custody, I will not be able to generate any income of any nature. My business requires my specific skills and daily input. I will eventually have to close my business down. My husband...
Surrender her travel documents to the state. That is all I would like to state for now regarding the bail proceedings. The statement, Your Worship, has been signed and duly commissioned. The state begs leave to hand it in for it to be marked as an exhibit. Support pieces. Your Worship, the state is also in possession of SAP 69s of the accused. May we read that, Your Worship? On the 14th of October 2009, the accused was found guilty of contravention of the Road Traffic Act, was sentenced to a suspended sentence for 2 years. On the 29th of September 2017, the accused was found guilty of assault. The sentence was 1,500 rand or 3 months in prison, and that was wholly suspended for 5 years. On the 24th of July 2018, she was found guilty of fraud. The sentence was count 1 and count 2 taken together for the purpose of sentence. 20,000 rand or 6 months imprisonment, which was wholly suspended for 3 years. Again, on the 24th of July 2018, she was found guilty of fraud, and the sentence was also taken together for the purpose of sentencing. 20,000 rand or 6 months imprisoned, which was wholly suspended. Another count of theft on the 27th of July 2018, also taken together with the previous one. 10,000 rand fine or 3 months imprisonment, which was wholly suspended. Count 4 was of theft as well. 24 July 2018, also taken together with the previous ones. Your Worship, the state begs leave to hand in the SAP 69s for them to be marked as an exhibit. So please, Your Worship. Your Worship, the state would also like to submit that when considering whether it is in the interest of justice that the accused be released on bail or warning, Your Worship, that the court be reminded of the first appearance of the accused before this court. She was asked, Your Worship, she was legally represented, and her legal representative informed the court she had no previous convictions, despite the previous convictions that had been handed to this court. The state is of the view that this shows that the accused was dishonest to the court, Your Worship, and also to inform the court and the accused that the state will be adding a charge of failure to disclose. The court should also take into consideration the assault of 2017. It is a similar charge to the one that the accused faces today, Your Worship. The investigating officer also mentioned this in his statement, which shows that the accused before court has a propensity of committing offenses, similar offenses in that case. Just after 2017, where she was on a suspended sentence, 2 years later, she finds herself having committed the same offense. This is something that the court should take into consideration when it makes its decision. And just to reiterate that the complainant is well known to the accused, and after the incident occurred, there were threats that the accused uttered to the complainant. The state would like to read a short paragraph, Your Worship, to the court. It is A1 statement deposed to by Kulu Eliwe. Paragraph 4. My sister Mbali of 46 Salukanda Street, Zamini, heard the noise and then she came out immediately, and she took me inside the house to clean myself, I then went to the clinic as my mouth was having a big cut. When I was at the clinic, Makhoto followed me and she was insulting me there at the clinic, telling me that she fears nothing and she has the money to bribe the police to drop the case. This is also some information that the state would like the court to take consideration of, Your Worship. The threats that the complainant endured after this incident occurred. With that said, Your Worship, that is the state submissions.